Julie. Next is Bart Legum. Is a founding partner at Onlet Legum. He has a Bachelor of Arts from Rice University, a JSD from University of Georgia School of Law, and also he studied at the University of Paris II Panthéon-Sorbonne. He has served as law clerk, as a U.S. official at the U.S. State Department. He acted as lead counsel for the U.S. government defending the first arbitrations against that country under NAFTA. Welcome.
Thank you very much.
It's a pleasure having you. Patrick Pershall leads Allen and Overy arbitration practice in the Americas. He has a Bachelor of Arts from Columbia College, a JSD from Columbia University School of Law. For nearly a decade, Patrick served in the U.S. State Department, working on economic diplomacy. He departed that department as the chief of investment arbitration, and now he specializes in litigation, arbitration, and other relevant matters. It's a pleasure having you here, Patrick. Thank you. Well, modern technology is around us, and in investment arbitration is currently playing an essential role. Proceedings now being conducted by having virtual hearings, for example, or using e-filing systems and electronic hearing bundles, and by relying in other applications and technology, different technology developments. I think that's the easiest part until now, but what we are going to see in the future is possibly more use of this technology, helping lawyers, helping third-party fundings. So let's discuss this. What would be, and what part of this discussion is, what about the technology of tomorrow? Basically, what role will the artificial intelligence play in investment arbitration, and how will, for example, we don't know what will happen in the metaverse. So we have divided this panel into three different main subjects, where I will be asking some questions. All the participants will intervene. So I will start with you, Patrick. What modern technologies are most frequently used in investment arbitration?
Well, first, let me auspicious start to a tech talk, right? But first, let me thank you, Go, and all of the organizers for the gracious invitation. I will always accept an invitation to Mexico City for anything. So please do invite me for anything, because I will be here, because the city is so spectacular. And I also was very much looking forward to coming to UNAM, which is pretty awesome on the number of great legal minds in the arbitral community that it's put out over the years. So thank you for that. The other reason why I was really excited to be here, before I answer your framing question, is this is one of those panels where 10 to 20 years from now, if we look back at the recording, we will all cringe. It's what will AI look like in investment treaty arbitration? That's the kind of thing that doesn't age well for a panel, right? Because 10 to 20 years from now, we will be so much in the thick of it that this kind of discussion will seem quaint and silly, and we will look back on ourselves, hopefully looking, somewhat similar, but nonetheless cringing at our prognostications about how AI will be used. So please take everything that we're going to say, or at least everything that I say, with a little bit of a grain of salt in that regard. But I get the very easy first question of what are the kind of familiar tools? What's the status quo currently, right? And these should all be relatively familiar to all of you who have practiced in investment arbitration. So the first, which is now very familiar to us all, but I would say 5 years ago, we might have been less familiar with, is video conferencing, right? So that is very frequent now. Most CMCs, most procedural hearings, the default at this point still remains, at least in my practice, to be virtual, including video conferencing. So there you're thinking about Zoom and WebEx and Teams. They can be quick and effective ways to meet clients, hearings and presentations done remotely to increase efficiency, right? We know that one. And this is the kind of building blocks of what we're going to talk about later today, about how innovations in these kind of building blocks are evolving. So the second is document management systems, e-discovery platforms. These cases tend to be relatively complex. They have often very large documentary records, good management tools, such as e-discovery platforms allow you to filter documents, categorize things, structure things in ways that then you can share among team members, your adversary, and the tribunal. So this shouldn't be shocking to anyone. I promise you, we get more innovative later. The third one, file transfers, storage areas, right? The first thing you do is set up your FTP protocol, your virtual file room. ICSID and PCA were one of the forerunners in using Box.com. Box is a useful platform. It has some security related issues, which has caused some firms to have difficulty with their firewalls. Obviously, those of us who practice in this space quite a bit have battled to get the firms to our firms, at least mine, to find a way to use Box successfully, happily. But Box is kind of what two of the largest institutions that administer these claims use. So if you're not familiar with Box, go check it out. But most of us now are using our own FTP and cloud systems, and that's mostly driven by client demand. Clients are increasingly asking for granular detail about the security protocols with regard to FTP and your cloud-based data systems. That's for good reason. Ransomware hacking is constant. So be mindful of your own FTP site, and I'm sure that the clients that you have will start to ask about some of that. Another basic building block, court reporting, interpretation technology. Often hearings are requiring simultaneous translation or immediate on the site kind of witness concurrent translation. So having translation services, which are still being done personally. I'm not sure whether that's going to persist, but generally it's an individual translating for the other person. There is, I think, as someone who's conducted negotiations in foreign languages, there's a real benefit to having a person, at least at this point, do that. But I think technology is evolving such that we're all going to have little earphones in our ears at some point, which will provide us with simultaneous translation, hopefully with the nuance that would be required to conduct a hearing. But it also requires things like soundproof booths and things like that. Watch that space. We're going to talk about how that too is being innovated right now. Two more things, and then I will cede. Displaying evidence. Clearly, displaying evidence is important at a hearing. Some people call this hot seating. Firms use a variety of methods to display evidence at a hearing. We're going to talk about that and how they've evolved and how they've been innovated over the last 2 years or so, and what we're to expect with hot seating coming up. And then finally, document drafting. that's a technology. Don't forget, most of us use Microsoft Word or some version of it, but that's just a way of introducing, watch that space, because drafting tools are evolving quite a bit. So hopefully that set the scene a little bit on the boring kind of things that we're all familiar with. That's the horse and buggy part of the panel. And now let's get to the Ferraris.
Also, it was Bart who has to make a comment on that part. We were discussing that at the Rice University where he studied had a computer, but I won't tell more about that.
Yes. So, well, first of all, thank you for having me. I'm delighted to be here in Mexico City as well. Right. So I understood the first question to be kind of a survey of what technologies are most used in investor state arbitration. And it's important in thinking about this that it's not just people like my colleagues here who are working at cutting edge law firms with, great technical support that are big actors in investor state arbitration. There's also two other elements that are years behind. One is the governments, which are generally poorly funded when it comes to technology, and the other is arbitrators. And I'm really, I think, of the first generation of lawyers that kind of grew up with computers. And the story that I told Hugo was that when I was a student at Rice University, which is a fancy engineering school, I took a computer class. And the way that you communicated with a computer was there were sheafs of cards and a machine that would punch holes in the cards. And then you'd take the cards out in a specific order and put them into a card feeder, and it would go, and the computer would then understand what you were saying. So the world has evolved a lot over the past years. And, when I first started practicing, there were no computers at secretaries' desks. There were electric typewriters, and people communicated with, telex. There was this new technology called faxes that people were using. So my point here is that in thinking about the technologies that are currently most frequently used, I think one of the most frequently used technology is paper, printers, courier services to ship the paper from one place to another and get it to the arbitrators who are most comfortable reading documents in paper, as well as all of the technologies that you've described.
Word technology. This one works? Okay, perfect. How many of you have used something like Google Docs or the collaborative version of Word? Okay, so just a good majority of people in the room. But you've used it for personal or business purposes? Who used it for business? Okay, so less people, but so I'm probably then talking to an audience that has experienced the power, has unleashed the power of collaborative Word files or Google Docs files when they can be secure enough, and when clients do give us the permission to use them and to access those documents on their own platforms. Specifically in the context of a hearing, I think that we have found that those are particularly powerful because of the instant nature of the communication that we can all have to get organized around a cross-examination, around some advocacy questions from the tribunal, et cetera, and to also keep that, have a neat file that you can go back to later after the hearing is over. Not to mention that the associates can be a little bit more of a integral part of the hearing, because they can really feed the information to the partners in real time, which is really tremendous and definitely an improvement over passing post-it notes during the hearing, for sure.
Well, you mentioned about the paper, but we think paper is relatively new in the human in the human society. It's obviously 3,000 years ago, but still is relatively new. Let's see next 5 years, as Patrick mentioned. What technologies must be used for best-in-class investment arbitration proceedings? Which is really what would be the must, Patrick?
Sure. So let's think about the kind of building blocks that I set out in the first question, then unpack them a little bit and say kind of what I think is probably best in class, or the things that are thought of as best in class. And reasonable minds differ on this, and everyone has their own pet technology or service that they are comfortable with. I clerked for a judge that insisted on using WordPerfect, even though WordPerfect was no longer even supported by WordPerfect itself. So, you know, people hold on to the technologies that they become. People don't even know what WordPerfect is. That's wonderful. I'm aware. When I started in the US government in 2009, we used Windows XP, which I think was a 1997 rollout. Leaving that aside, to Bart's point about how governments are poorly resourced in this area. But what are best-in-class technologies that you would find at any of our firms, for example? One, I think one platform is really becoming a very beneficial way to think about best in class. So one platform that does a lot of things. So a consolidation of one technology, one software. And the reason that's helpful is it moves aside some of the compatibility issues of multiple platforms. So firms are looking for one or two, depending on what they're wanting to do, platforms that really can do all of the services. So you've seen the market consolidate around certain big services. So for video conferencing, leaving aside the software question, some best-in-class things to think about is make sure you're hardwired to the internet. You don't want to have Wi-Fi related concerns. You don't want to to try, that doesn't present well, right? You want to be hardwired in. Second, if you have the resources to do so, build studios. So we at our firm have spent a lot of time over the last 2 years building, a studio that looks nice and has soundproof this and fancy cameras and all of that, microphones and lighting and things like that. If you can do that, do it. If you can't do it yet, you're going to be able to do it at some point, because the price of that has dramatically decreased as competition and need have spurred innovation. Second, on video conferencing at hearings, I think you would want a dedicated host, right? So either the firm or a vendor service that will monitor the hearing, right? Check the muting, figure out tech issues, make connections between offices, help with screen sharing, basically a producer. And there are lots of options out there, but you want to hire someone to kind of be the producer of this performance, really, this advocacy moment. Displaying evidence. This one I've really think over the last couple of years, we've seen a real sea change in how to present evidence. And this, you don't just share your screen, right? I was at a hearing once where it was a big hearing, a public hearing for the United States, and an advocate shared his screen, and not a US government advocate, and shared his screen, but then it timed out. And then it was just pictures of his vacation and his wife and him shirtless. And it was just so don't just share your screen, right? So there's that concern, but also there's so much more that technology allows you to do than just share your screen. So for example, you have the key document, right? Every case has like 6 or 7 documents that you constantly go back to, right? So it's the share purchase agreement addendum, let's just call it. So you know, you're going to go back to the SPA addendum time and time again. What you'll see previously is an arbitrator go to the bundle and she opens it up and then she's marking it up and then puts it away and then coming back to it. So you go back to it and marks it up again, and the experts. So everyone's got their own little copy, and it keeps being put on the screen, but putting on the screen is unhelpful for the arbitrator because she's already got all of her notations. So she's doing a lot of this. That takes her out of the game, right? So now what's available are document sharing platforms like Delium. Delium's a really good one. If you don't know it yet, I'm a big fan. But what Delium allows you to do is bring up individually their version of the document. So you bring up the SPA addendum, but the SPA addendum for the president, it's her marked up copy every time it comes up. So when you say, can you bring up the addendum? Everyone's version securely, no one has access to everyone else's version, would pop up. So she has her version, right? And it allows her to make markups on her iPad or whatever that will be maintained and persist throughout the arbitration. And that's so crucial, right? And it allows experts to be very manipulative in a good way of the document while they're on the stand. So that's one thing to think about in displaying evidence. I don't think, sadly, I think I think paper's had a good run, 3,000 years, right? But it's not gonna. I don't think that as our generation becomes more senior and takes more arbitrator positions, if that's the natural life cycle of an investment treaty practitioner, who knows? But we're not going to want paper. I wouldn't want paper as an arbitrator. Give me an iPad, give me something electronic that I can manipulate. Why? Because what you want is an arbitrator on their flight from Paris to Zurich to open your document and have like their little glass of red wine with it. But like, they're not going to go up and take down the bundles and open them all up. They're just going to whip out their iPad and drink their, bad BA red wine and then read their iPad. So if you have it on the iPad, you've got them, right? So think about paper as also a burden, even though some people still find iPads difficult or electronic devices difficult. And then I'll be quiet in 1 second. The last thing is document management and e-discovery. So there are great things right now in document management and e-discovery. So I like a process, a software called Evercron. People have their own choices, but Evercron allows you to create timelines, automatic translations. It's got a file sharing service. It allows you to draft briefs or cross outlines that are linked to key documents immediately. It allows you to integrate transcripts, sound bites, videos, maps. It's really a great platform. So whatever platform you choose, make sure it allows you to do all of those kinds of things. And those are really some of the best in class, I would say.
So I would just echo what Patrick said about paper. Given the size of the files in these investor state cases, it's simply not practical to travel with the entire record, unless you're traveling with the entire record on something like this, a tablet that can display each page in the same format that it was originally presented in. So I think it's really important for counsel and for arbitrators to find a means of displaying documents paperlessly that they're comfortable with, and ideally one that's portable, so that they'll be able to be prepared or be preparing on the move and in a wide variety of different contexts. The other two things that I'd say, neither one of which is new, but neither one of which is necessarily widely adopted among certain parts of the investor state arbitration community, notably arbitrators, is time tracking and billing software. So, there's for people who've grown up in a law firm, it's natural to have, a software that keeps track of your time so that you can record it on an objective basis, day after day after day. For arbitrators who come from different traditions, like law professors, for example, they're not used to that. And the result is that you can have differences in the amount of time reported by tribunal members that may be a little surprising, as between those who have time management software and those who do not. And then the final thing I mentioned is encryption, which, as Patrick has said, is increasingly important in this world where there's more and more cybersecurity attacks. And of course, investor state arbitration can give rise to other much better equipped actors being interested in what happens in a given case. And so it's important for arbitrators and all of those who are involved to become familiar with encryption and ideally use principally secure platforms like ICC Connect or the box, which I think has made some security improvements in recent years, or the SEC platform to access documents, because what I see in a lot of cases is USB keys being sent around with the password in the letter that is accompanying the USB key, which is of course completely useless.
User of having a very elaborate chronology of documents and linking documents, which of course in our line of work is a very important tool. So think of it as a fancy, a glorified Excel spreadsheet, but that has a lot of functions to allow you to sort things in a way that would make sense for chronology purposes in a case map. The name suggests everything that the product is meant to accomplish. It's a good one.
Thank you. And I think until this part, more or less everyone say, okay, that I have used that, or I will take note of this new software. But now in part two, the questions that I would like to have more, and your replies is, what is coming in terms of new technologies in investment arbitration? Again, we'll start now.
Given that I have slides, should I go to the podium so I can, because there's no screen here, so it might just be a bit easier. I think there's a clicker here.
Yeah.
All right. So we are going to chat a little bit about artificial intelligence in investment arbitration. Who has given ChatGPT a try in the room? Okay, good. So you have a sense perhaps for what it can do. Artificial intelligence is really clearly the next thing, or maybe it isn't the next thing, it's with us. But I think along the lines that Patrick was suggesting earlier, we can't quite yet wrap our heads around what it is going to be able to do and not do. And we had a presentation at our firm recently with someone who's very well steeped into the technology. And what I took away from that presentation is that this person was almost keep getting it wrong in terms of the ability of artificial intelligence to do certain things. Like he thought 5 years ago that it couldn't do X, and then it could do X, and then it couldn't do Y, and then it could do Y. And so I think what we have to be mindful of is exactly what Patrick said, which is we humans probably don't quite have the ability to even imagine what it can do. So recognizing the limits of the exercise, which is the way we started, it's important to understand that this is really technology based on the human brain and with the ability to learn and progress on its own. So that's really the key. And I think I won't go through all of the slides for time reasons, so you can take a look. But I think we, and you have all read about in terms of general news, the ability of artificial intelligence to do great things, including writing screenplays, which I think is really interesting. In the arts world, the songs, you've heard about the songs that were produced, and we have tremendous intellectual property issues around that. But if we want to bring this to the world of law and the world of investment arbitration specifically, there is one product specifically which is called Co-Counsel, I think very wisely crafted as an aid to us lawyers, so we don't feel overly threatened by the product. Okay, here it is. So this is really meant to be helping us. And this is actually one of the examples that we heard about in the presentation that I was talking to you earlier, where the artificial intelligence was able to give an accurate read of whether or not a document was privileged. And it was able also not to fall into certain traps. You know, if you put privilege all over the document, but really it doesn't actually involve lawyers, but it sounds like it might be privileged. Artificial intelligence was able to recognize that it was being tricked into believing that this was a privileged document, which is really quite interesting. If you want to give me, I don't know if I'm able, do I have control? I'm not sure that I have control for the slides. This is how it starts, right? It's ChatGPT is already in charge. But I think we're going to find that it is hugely helpful to us. You're in the middle of a hearing, you want to know what the witness said. You're just going to be able to just ask the program to tell you what did Francisco say about X, and it's going to give it to you right away, back at you instantly. And of course, in terms of analyzing documents, going through transcripts, it's ChatGPT is already surveying the whole of the internet for you when you ask a question for it. So the notion of looking at the record of a case, almost by definition, right there that it can do it, even if the record is massive. And oh, by the way, on ChatGPT, I was telling Patrick earlier, one of my favorite things is actually once it gives you the answer, ask it to give you the sources, which it will do, and then you can test what it's given to you by looking at the sources a little bit. Ethical concerns are tremendous in this area. Law firms are currently grappling and will have to grapple with tremendous questions with respect to the ethical use of the technology. We'll give you, of course, a few examples. I think there's going to be a great deal of, I don't want to say incentive, but there's an appeal to wanting to use the technology to see what it can give you. People are working hard. And of course, if the technology can facilitate the work, I think there are great incentives to potentially do the wrong things by putting in confidential client information into a tool that is not made to protect it and would violate all sorts of rules for our clients. So we have to be careful about that. Not to mention that even if you don't provide confidential information to the software, you have to recognize that whichever legal advice you're getting back may be fraught with all sorts of difficulties and challenges. But I think we do have to recognize as legal organizations that there's great temptation, I guess is the word that I was looking for earlier, for many generations of associates. And this is why we have to develop our own products. such that we can protect our clients and really use only the products that will be protective of their information and their legal advice. I'm just going to go over a little bit more quickly. Fabrication of evidence, right? I mean, this tool, you already know, creates songs. It creates all sorts of things. It can't quite yet create images, but that's probably coming to a theater near you in 2 weeks, right? It's moving so fast. How are we all going to be able to tell the truth? It's going to be extremely difficult. Just a few days ago, I received a phone call. I picked it up. I started talking. I didn't immediately recognize that I was talking to a robot. I really didn't. It took me a while. And I think this is exactly what we're talking about. We're going to be looking at documents. We're going to be looking at things, and it really won't be obvious at all that we are looking potentially at manufactured evidence. And I think the artificial intelligence in the right hands will be bringing us and making us do leaps of progress into the future, and in the wrong hands will create all sorts of hazards for us. So we're going to have to be extremely careful. Of course, this is just the American rule about providing accurate and truthful information to courts or tribunals, but this is going to be, one would think, something that we're going to be talking about quite a bit in future years. So this was a question that we put to ChatGPT, asking it to draft an award, to pretend that it is an arbitrator. Not too bad, right? I mean, and this is within seconds. Many of you have used it, so you know that one of the things that just blows your mind away is the speed at which it is giving you the answer to the question you posed, right? This is just a provision about the independence and impartiality of the arbitrators. This is another question that we put to it. Those are all real. We didn't manufacture those slides. These are real questions that were put to ChatGPT about the things that it can do. So you obviously can get a draft memo if you want. This is the temptation that we talked about earlier with some of the associates who may want to just try this out a bit, raising the concerns about the competent representation of counsel. One of the tremendously impressive features of ChatGPT and artificial intelligence in general is its ability to simplify the answer that it's giving you. You may want to try, after you get the answer that you want, to challenge ChatGPT further and say things like, explain that to me, but pretend you're speaking to a 15-year-old or a 10-year-old, and you'll get a simplified version of it that is really hugely impressive in terms of, it is the same content that you were just reading a minute ago, but in simpler terms. It's fascinating. I was talking about the current use of case map earlier, right? The case map is currently human generated. There are associates typing in the entries, you looking at the documents and typing in what they're saying, and we're preparing the chronology accordingly. Well, I would think it won't be too long before, the artificial intelligence version of case map comes onto the scene, where it will review the documents and spit out the chronology. And then, of course, we come in to review it. But this is the new skill that we have to develop, which is going to be really the oversight of all of this, and how to use it without becoming, victims of the technology that is meant to be helping us. We've asked ChatGPT to write an email as if it were me. And you can tell from the answer that you're looking at on screen that it immediately went to my bio. And from that, was able to put it, a decent sort of, based on my experience, I would say X, Y, Z. It's not bad in terms of what the kind of thing that you're getting within, again, 5 seconds of having typed the question. And you can get it in, in verses as well. Thank you.
I have now 2 concerns after hearing you. Maybe some associates have been using this long time ago and saying, how can this guy is giving me this memo very quick? Okay. And also possible concern is the use of energy and how this is polluting, right? That's another part of how the algorithm, these kind of algorithms are polluting because are high intensive in energy. But Bart.
Well, I think that Julie has really said it all. I mean, the only thing that I would add is that one other important element of investor-state arbitration is translation of documents. And already there are excellent AI-based translation services that produce translations that are very quick, where you can essentially paste into the service an entire document that's 100 pages long, and it'll give you quite a good translation within just a little while. And as the technology matures, I expect that this will become better and better. Currently I use something called DeepL, where for 40 euros a month, you can have 100 documents translated, and it's by the document. It's not by the page or the word or anything like that. So it's really quite effective.
Yeah, I don't have much to add to Julie's presentation either, only to say a couple observations on AI from my own perspective, and then to put down just a couple other, cutting edge future technologies in investment arbitration. First is, I think it bears reminding that all of us right now are probably the most vulnerable generation to AI related scams. We don't have the tools yet because we haven't been exposed to them, to AI sufficiently to understand that we're talking to a robot, right? We're a little bit better, hopefully, on like seeing an email address come in that doesn't look right and then thinking that that's spam and not, but we don't even know at this point what we don't know with regard to recognizing fake, right? So we're particularly vulnerable. The second thing is we're also probably at this point the most equipped for interrogating AI like ChatGPT. Why? Because Bart, Julie, and I have spent the majority of our career going to first sources, books, cases. We've read them. We can tell you this doesn't actually give us the right holding of X. This doesn't actually give McLaughlin's take on or Schroyer's view on, right? Because we've read those materials, we're steeped in them. Future generations, future classes of lawyers won't be as steeped. Not because they're lazy, I hope, but because you won't have that kind of go to the primary source instinct and get steeped in it. So saying, show me your sources, ChatGPT, that's fine for someone who can read chapter and verse like Julie can on investment law, but it won't be fine for someone who hasn't actually done that foundational work, right? So that's a second observation. Third observation on ISDS generally is, recall ISDS or investment arbitration is meant at base to be the peaceful settlement of disputes consistent with the rule of law, to not have, as we heard last panel, the British bombing or shelling the ports of Buenos Aires for debt, right? So, we are really working on issues of justice and sovereignty and strategy and foreign policy. And that calibration, whether it should be in the hands of us anyway, is a different question. But that calibration really needs to be guarded from kind of ethicless, is that a word? Moralless technology, right? Which doesn't have kind of a purpose, right? ISDS has a purpose. And then third, just imagine what this is going to do to arbitrator research. I mean, it's going to be crazy. So watch that space. Fourth, privlogs. And this is just the point on money. It used to be you could make a decent amount of money at a law firm charging a client for priv reviews and creating a privilege log. That's going to go away probably, right? Clients aren't going to want to pay for that when a chat bot can do it pretty well. I don't say that to be cynical. I say that because the economics of law are radically going to change in the next 5 years, 10 years. So if you are a junior associate or a junior lawyer, or you haven't yet graduated, my advice to you is be very aware of this, right? But also find ways to become expert in it. Because if you are not going to be expert in it, it will replace you, right? And then last, just 3 things that we haven't mentioned yet. And I think Bart's going to say more about this, so I don't go into it, but metaverse. The metaverse is happening, right? So, virtual hearing spaces where you can like walk around in the virtual hearing space. I think Colombia, the country, just had their first hearing in the metaverse, completely in the metaverse for a traffic case. And you can watch it online. It's pretty fascinating. But simulations for what arbitrators are going to ask your witness. You could create a little, Judge Sepulveda simulation where he, based on all of the questions he's ever asked publicly at the ICJ or elsewhere, he will then, it'll think about how he will ask questions and put them to your witness. And you could just simulate Judge Sepulveda, right? So that's happening and coming. And then last, 'cause I don't want to drone on, but drones. Drones are going to be very important for evidence gathering and other activities in investment arbitration. It's impossible for a tribunal to go for a site visit, but if you have a drone, it'll be hard for them to not think that that's probative. And there are people on my team getting their drone licenses for this very purpose. So drones are coming. I'll stop there.
I just received a message saying, well, to use this complex technology or microphones, you just, I need that activates. Okay, that's enlightening. But now how the artificial intelligence is being used in your practical point of view in investment arbitration? Maybe this, I assume that no one is going to provide a memo just based on asking ChatGPT, but maybe this is like a second review or something, or just as a tool to complete your work. Yuri.
Let's see. No. Yes. Wow. It worked. Yes, the answer to your question, of course, as we were discussing earlier, is there might be an ability to get some of that quote unquote advice. People will call it advice. And by the way, I didn't even mention that ChatGPT passed the New York bar, which I should have, 90th percentile. I think, some of you may be aware of this, including the essay portion of it. So yes, with this ability to look for and search in the investment arbitration world, different from the commercial arbitration world, the awards are all pretty much out there. And so clearly there is an ability for artificial intelligence to gather a lot from surveying cases quickly and giving information. But I think that's the way to do this properly, is actually really to refrain from thinking that artificial intelligence can give advice. It is a glorified document reviewer that is really good at looking at a lot of things in a short period of time, and that can be very helpful. And then you have to, as you said, come really on top of that, check what's been looked at, see what's missing. Patrick's point about, who and where are the people who will actually know that there's something missing. That's what we have to work on in terms of creating value. That's where the associates have to know that this is where they will be creating value for their teams, is they have to be those associates who actually know that whatever the artificial intelligence program just spit out is actually wrong. Or can't be relied upon, or needs to be fine-tuned, et cetera. So this is what we have to become, good at, for sure.
I guess the only thing I'd add is that the notion of arbitrators using one of these AI-based services to have the first draft of an award prepared fills me with great unease, because the essence of what the arbitrator is supposed to be doing is to be deciding the case him or herself, thinking through the issues him or herself. And if that element of thinking is being done by an algorithm, then that strikes me as seriously problematic. And so the thought of an arbitrator saying, I've listened to the hearing, please write an award where party X wins, and you get a compellingly drafted award, even if that's a first draft, that's not right.
I sit on the ICC court, and that's a scary thought in terms of the scrutiny of the awards, for sure.
100% it's going to happen. 100%, right? Guaranteed certainty. So for us, so at A&O, we for 5 years spent time researching AI technology and have built out a proprietary software tool called Harvey. And we did this big splash in February, and it was like this big thing, but it's completely self-contained within A&O. So only A&O folks can use it. It's completely secure. It uses ChatGPT for tech as one of the inputs, but it really is meant to be just a legal tool that learns how we do things. And it's remarkable, similar to Julie's examples, but it's remarkable in that it gets to know you and what you're worried about and how you look at things, right? So it now has learned how to draft in my style. And in my style to a point where I didn't realize that I didn't actually draft part of that, right? So I would know if I were Julie that maybe I wouldn't start a sentence. Throughout my career, I've been very complex, right? Because that's not, I mean, I know Julie, that's not really, I would be surprised if she started a sentence like that. But, this kind of, the way I'm presenting to you now, AI has learned that, right? I might think that I'm complex and unique, but AI knows, oh, Patrick likes to do this like quip at first, and then he, shucks and jives and does, like, that's scary that AI knows how to do that. So it's important to keep that kind of self-contained and proprietary within your small ecosystem. So we're doing that. Two other things. One, AI can be very helpful and is currently being very helpful in real-time help in drafting. And by that, I mean, as I'm drafting or as we're drafting a brief, a program such as ClearBrief will be in the background searching the entire record for the best source for me for that sentence, right? So it will find, the best document based on the sentence that I'm drafting. Other programs do that, Quillbot, WordTune, WordAI. Those will kind of help you avoid inconsistencies across the thousands of pages that you're drafting. And also in hearings, AI can be very helpful. You can have an AI tech adjust the lighting and the sound for you. You can have AI examine the arbitrator's responses to know whether they're losing some concentration, whether the volume needs to go up. It's the kind of most annoying version of someone passing a Post-it note to tell you to pick up your energy, right? And that's happening. There's all sorts of other things, which I don't have time to get into, but there's another very interesting use right now in some of the softwares. One's Disco, one's Relativity, one's Reveal. And what it does is it looks at your record and predicts the result. Which, if you just think about that, you could be like, whatever, it's predicting a result. I guarantee you clients want to know. Clients want to know what the software says is going to be the result, right? And managing a client's expectations on that is going to be very interesting for us as lawyers going forward.
On the third part, someone has already mentioned the metaverse. Is the metaverse an area where arbitration is required? I'm just saying not only within the metaverse, but around the metaverse. Around the metaverse, there will be some disputes. When you are using the metaverse, you are clicking on accepting certain contract. So, and there are also within the metaverse transactions, but around the metaverse are also transactions. So, you have any comment, Bart, on that?
Sure, I'll begin, but I suspect that my co-panelists probably know a lot more about this than I do. So first, let me begin with a definition that I found on the web, not using ChatGPT. So it might not be the best possible source for the definition of the metaverse. But what I found was it's a single, shared, immersive, persistent 3D virtual space where humans experience life in ways that they could not in the physical world. So that's the concept of the metaverse. And your question, Ugo, is kind of based on the idea that the metaverse is a place. Mm-hmm. And from the perspective of the current legal framework that we operate in, it is not a place. There's no place that's the metaverse. And so is arbitration required for transactions in the metaverse? It's not required because it's physical people that are engaging in these transactions. And as a matter of theory, you could always sue the respondent in their place of residence. There's some jurisdictions like France that have rules of jurisdiction where a French person can sue anyone anywhere in the world at any time in French courts. So arbitration is not required in order to deal with the metaverse, I don't think. Now, if your transaction is an anonymous transaction where it's a green bunny rabbit that's an avatar that's entering into a transaction with a orange giraffe, then under those circumstances, it might be difficult to identify the physical person that's behind the transaction. And so there, the only way that you could have dispute resolution might be through some kind of contract-based system. But that wouldn't give rise to an enforceable arbitration award unless the arbitration agreement provided for a seat in a real place where the current legal framework would recognize it. So that's, I guess, the way that I'd begin an answer to that question.
I don't have much to add. I think the metaverse is very much hello. I think the metaverse is still very much in its infancy. It's also very expensive and it's also very silly. I mean, so I don't know. And in investment arbitration, where the stakes are so high and you're dealing with really difficult questions of sovereignty and public welfare and investment, you query whether that works. I was reading one scholar, and I'll just give this quote. The metaverse holds potential for investment arbitration by offering virtual hearings, immersive evidence presentation, and enhanced information sharing and collaboration. That sounds good. However, its successful implementation depends on challenges related to privacy, data security, technological infrastructure, and gaining acceptance within an often skeptical arbitration community and legal institutions. The exact role of the metaverse in investment arbitration therefore remains uncertain. Its transformative capabilities could shape the future of how arbitration proceedings are conducted. And that scholar, of course, is ChatGPT. Just answering the question that I typed in, could the metaverse work in investment arbitration? I'd be happy with that from an associate, right?
How many of you have tried these goggles for personal reasons? Anyone? Yeah. Okay. So, I mean, I have two, not for business, but for personal reasons, and I have found them to be quite uncomfortable, felt a little bit nauseous using them, but I think the technology will improve. In just a few months, I'm sure it will be light, and I won't be anymore having to worry about being so nauseous doing it. So it's another thing that is a little bit in its infancy, but will soon improved in a way that instead of having 3 people in this room who will have used it, you will, all be using it for personal and probably business reasons too. Because if it becomes pleasant, which it can, I think it could, at some point it will be. Currently, personally, it doesn't cut it for me. But when it will become pleasant, then I think we're going to see a lot of changes.
Let's wait for the next editions of this Mexico City Investment Arbitration Days. Maybe we will use the metaverse. But a final comment, Patrick, in 1 minute, and then Bart, and then Julie.
Okay. Well, I didn't ask ChatGPT what my final comment should be, so I don't really know. Here's my final comment. My final comment is one of the reasons why we like practicing law is because we all get to know each other, and we have a community outside of our home jurisdictions, right? I have friends in Mexico City. You have friends in Washington because we've known each other. That level of human touch is essential for justice and equity, and also client interaction. So I don't think it's going to go away. I don't think a client would feel as comfortable allowing me to appoint Julie as an arbitrator if I wouldn't able to say, no, I've seen her speak. I know her. You can trust her. She's first-rate mind, right? Same with Bart. So that is not going to go away. And I don't think clients will accept goggles for that.
I guess the only thing that I'd say, I completely agree, of course.
Oh, wow.
Sorry about that, everybody. The only thing I'd say is that there have been a lot of advances over the past years in cloud-based computing that makes it much easier to practice at the highest levels in terms of technology in this field for small firms and for arbitrators. Because before, if you were really going to practice to the level that was needed in terms of security and everything else, you'd have to have a server that was in a secure location that you could have all of your software running on, like the big law firms have. They have their own kind of server farms, or at least they used to. And that's true of governments as well. But now with cloud-based services, there's a means of having secure access to the same, actually better technology than that of many of my friends in law firms for a reasonable price. And it's also has the benefit of being completely portable, which is great.
The last thing I will say is I'm waiting for the technology that still hasn't come, that I've been waiting for my entire life from like childhood watching TV, which is teletransportation. That's the one that I think will be really very useful to any number of us.
Instead of traveling 12 hours or 8 hours. So we still have time. I'm having the advantage. We are having the advantage of being the last panel of this edition. So I think we can pick up some questions from the audience.
Hello, thank you. Thank you for your comments and the organizers to bring these events to the UNAM. The question is, we already talked about technology, information, storage, and I want to know your your comments about data privacy and this fluctuation of information in investment arbitration. And if it's a real concern as the claimant in Tennant versus Canada raised in this issue.
Can pick up two other questions and then panel will reply. ChatGPT.
Hello. So you said at some point that the artificial intelligence tools will be able to create copies, right? So now, currently we are in a trend to accept more and more copies, to virtualize everything so that we don't necessarily need the originals. So how do you reconcile that we don't want paper anymore, but at the same time, the copies won't be reliable? Then I have a second kind of comment. I'm not sure you would have the answer to that. I've used ChatGPT and I'm still finding it quite useless because, you know, I ask it a question and then I usually tell it, are you sure about that? I'm very surprised of your answer. And then it replies me, oh, sorry, I got confused, and tells me the contrary. So, you know, I had this reaction, and actually I asked questions not in English, in French. And I heard that it was not so reliable in other languages than English. So when do you think that artificial intelligence will be able to provide reliable information that we won't have to check? Because for now, it's just something like, you know, when someone does like draft a document for you and you spend more time redoing everything than if you had done it yourself from the beginning. So I don't know if it will happen once.
I don't know if this is a question or a comment or both. But since I work in a law firm that took, I will say encouraging decision to open an office in the metaverse the last month, and it's a little bit, I know to use the Google's is a little bit silly experience, but at the same time, not particularly on investment arbitration, but what we saw is that there is an investment there, particularly in these issues of the NFTs that is based in the smart contracts that probably will bring disputes between private parties that deals with commercial arbitration. I'm not completely sure because these terms are basically based on the smart contracts that has some provisions on dispute resolution, but probably there is also there some spectrum of investment, but not necessarily investment that could be trigger any taking from a state, but it will become more and more useful, or more and more cases of disputes between investors that make investment in that area of the digital environment, no?
As I was listening to you all, it is all very interesting. And I was wondering, I use many tools, not the ones that you referred to, and I have never used ChatGPT. In fact, I only learned of its existence probably 3 or 4 weeks ago. But I do use a lot of tools. I build my own timelines, and that, you know, I look at the documents, I annotate them, I highlight them, and I take notes and dump into the timelines. And that's how I do my facts. And then my legal research, I look at the documents, highlight them, I annotate them, and then I dump my own notes into a different software that allows me to connect, you know, different ideas or cases or sources across cases and categorize them. And it's, but it involves a lot of time, a lot of work, and a lot of effort. Now that gives me personally comfort that I've looked at the documents and, you know, if something comes up, I've seen it. But especially listening to Patrick, there seems to be a tension between that and then asking ChatGPT to do all that. Okay, well, you, Julie, you showed us a timeline for the Cargill case. So will the tension, you know, how do you think it will be resolved in terms of the easy way out and asking, okay, review the documents and give me a timeline? And, or for somebody like me, having the comfort of actually having looked at the documents and done the timeline, but it takes time, effort. And, you know, I think I fear that I'm going to be on the losing end, but I would like to hear your thoughts on that.
Last question first, because it's a very good one. And as you were describing your concern, it occurred to me that we need to bring ourselves back to the time when all of a sudden we had a lot of documents to review, because that too is pretty recent. And we found ways to become comfortable with some choice, some selection, some review of documents that we as counsel, as humans, gave us the sense of comfort that you were just describing about knowing the case. And I think, and this was a challenge when we first, had millions of documents to look at for our clients. And I think we will adapt. And the next level of comfort will be how to use the information that the artificial intelligence will give us to support us in our work and get that to that level of comfort that we feel like it's reliable. And I have no doubt that we will develop tools to do that, because we have to. Otherwise, we wouldn't be serving our clients. And I think it's just probably just a matter of time before we develop enough quality control measures that we somehow get to the point that you were describing about the document review. I'm an optimist.
So I'll take the pessimistic view then, just for purposes of good debate. I too do what you do. I handwrite things in advance so that I can internalize it. There's some pedagogy there in going to the documents as a primary source. I feel like that's an obligation that I have to the client, because I think that the decision maker, right, cares about that. They care about my mastery of the documents. They care about my ability to own the record, because that's persuasive. It gives me credibility, but it also allows me to be a good servant of them to make a proper decision. Here's my fear. My fear is it will happen instantaneously in the future, what you do and what sometimes I do, instantaneously. Here's the output. Ultimately, that will erode the decision maker's care about that. They won't care, maybe. Hopefully that's not true, but pessimistically, the decision maker might not care about your mastery of the record personally. They just want to know that the output is there, and they will decide it in that way. So the question that concerns me is, we might get to a point where that comfort that we all want before we go into a hearing is not necessary. It's unnecessary for the actual result. And if we get to that place, the market will adjust, and those lawyers unborn won't do that. And there will be a change. We might not think that change is good sitting where we are now, but it's also probably value neutral, right? If the result is one that still we can live with.
If I may offer still a third view. So I guess a couple of things. So first, I'm not sure that the decision makers, you're referring to the arbitrators, I don't think they care that much about your mastery of the record. What they really want is to understand the record themselves. And the reality is that, just like writing and thinking are two totally linked activities. I mean, I can't deeply think about a complex legal or factual issue without writing it up. And having someone write it up for me or someone tell me what the answer is, that's not going to help me make a decision. I need to get there myself. And the way that you get there is by doing what Ugo has described, where you go through the documents and you figure out what happened and draw the correlations between the different elements and arrive at a decision. Because at the end of the day, at least as long as humans are the arbitrators, they're going to want to feel, they're going to need to internalize what's being said. And I don't think that work can be really shortchanged, although I suspect there will be some people who will do it. So we had a lot of other questions too, right?
Fire those?
Yeah. Yeah.
We'll do it really quickly.
Yeah.
Should we do it really quickly?
Yeah.
5 seconds or less. Data privacy and ISDS. Yep. It's going to be a really difficult. Data privacy in investment arbitration is one of the most pressing, important questions that exists, and AI both can help that and make it worse. I'm sorry, I can't be more elaborate with my answer. Reliability of data, right? And when will we not have to check? If you believe us, you always have to check, right? You won't have to check if the stakes are low. But in investment arbitration, the stakes are never low. So I would say you always have to check. And then third, you didn't ask a question, it was more of a comment, but I'll give you a question back. What are the benefits to the client of having a metaverse office? Like, are you attracting clients that are more cost conscious or, happy to not have you around? Like, that's the question. And if there's a client need or a client attraction to a metaverse office, it'll happen. We're ultimately providers of a service.
One additional word on that topic. In terms of the conceptual question of, is an investment in the metaverse an investment covered by an investment treaty? Under the current treaties that we have, they're defined by physical territory. And so if your server's farm is located in a specific country, then it might be covered or it might not be covered. But I think that would be a really difficult case.
And just a word on your question about whether we might need to just go back to the originals to ascertain the veracity of some of the documents and whether they are genuine and have not been forged. I think we won't go back to the originals. I think artificial intelligence will be developed to do a quick scan, if you'd like, of the documentary record and tell us about the ones that are looking fishy because they were all the metadata and all of these things, they were created. I think we'll harness the power of artificial intelligence to tell us which documents may be suspicious. Yeah.
Well, thank you, sir. As I mentioned at the beginning, this was should be a very fantastic and wonderful panel. Thank you to the panelists. Passing the floor to Ian to close, I just want to say thank you. RRH, Van Bael and Bellis and the World Arbitration Update, which organized this, and also thanking the university, the Faculty of Law and the Institute for Legal Research for having us yesterday and today, and also on Wednesday. And for the people, which was more important is the you that are or were listeners were during these 2 days, and I hope you enjoy the speakers, Mexico City, and we hope we'll see you in the next edition. Please, Ian.
Thank you so much, Hugo and the panel. This was a fantastic discussion, and I'm going to urge everyone practicing arbitration in my firm that this is a must watch panel, because a lot of these issues, frankly, are new to a lot of us, and the technologies are advancing rapidly, and it's part of our obligation, I think, to get a handle on it. Just on behalf of World Arbitration Update, again, I just wanted to thank UNAM and the organizers of Mexico City Investment Arbitration Days. It's been a fantastic 2 days, really enjoyable, some great discussions. And it will continue next week. There are 4 more days of World Arbitration Update. Sorry, Freudian slip there. And Monday is going to be a particularly busy day because there's a lot of overlap with panels being held in the Middle East and in Singapore. So I think there's like 6 panels North American time tomorrow on Monday. So look at our website, and hopefully we'll see you at some of those future panels. And thank you very much. And thanks for everyone here today.